Hello, my name is Maarten van Munster and I'm the module manager and also one of the lecturers of the module The Legal Dimension of Europe. This is the first video in a series of videos that I will make of each lecture for this course, and I'll call them video casts, very fancy, they will be posted on the Blackboard every week. And the idea is that you can have, you basically have a short summary of the lecture in maximum of 20-30 minutes. I try to stick to that. That you can watch in preparation of the lecture, in preparation of the seminars, and also in the end in preparation of the exam. The idea is with this video cast is not to replace the actual lectures, but to give them some extra support. I will have office hours should you need to talk to me in person every week. I will announce the exact dates and times for that once the schedule is announced. And then you can find me in OVAL 427, which is my office. You can also reach me via email, and my email address is m.vanmunster@hhs.nl. Although I prefer not to be emailed too often, only in case of very important questions. Unfortunately, my email box is taking up a lot of my time these days. Good. In the lectures we always start with some pictures on the first slide, and the pictures have a link to the topic of that week, so that is maybe some good information to start off with. For this week we mainly have an introductory video today, so there are not many pictures that could link up to that, but I decided to focus on the court here and the justice part of the course. After all, we're talking about the legal dimension of Europe here. On the left we see the first symbol of that, which is the towers, the two buildings of the Court of Justice of the European Union. They look like two golden towers, as you can see. The Court of Justice of the European Union, as you may remember, is the highest court of the EU, and it has a very important role in this course because we will be using its case law quite a lot, and we'll be referring to the court also quite a lot, for example when we talk about judicial protection. So that's why it's good to be familiar with it and to know about it. The third picture is from inside the courtroom, and there we see the justices in the court room itself. And the second picture is the Strasbourg Parliament, so the European Parliament in its plenary session in Strasbourg. And why is that relevant to a course on legal issues? Well, you probably guessed it, because after all, the Parliament is the legislator together with the Council. So they make the laws, such as directives and regulations. And the last picture is Lady Justice. I thought it would be appropriate to introduce Lady Justice here on the first slide. A beautiful depiction, of course, symbolic depiction of what the law and what the court should be about as well, and what justice should be about. The blindfold symbolizing, of course, the impartiality and the independence. The scale symbolizes that she needs to weigh different arguments and weigh different interests. And the sword, of course, depicting her decision-making power in terms of issuing judgments, for example, as the courts do. So this is what we'll be doing today. Some general information on the module, I'll start with that, then a little bit of history lesson on the European treaties, and finally we'll talk about the legislative framework of the EU. This might be a bit repetitive for the regular students. You've heard about this already in Institutions of the EU and European Public Policy, but it has been some time ago, so it's good to freshen up that knowledge. And besides, we also have some exchange students in the class who are maybe new to this. About the module, I think the four learning outcomes, expected learning outcomes that are on this slide, will give you a good idea of what is expected of you in this course. So what we expect you to be able to do upon completion of the course, successful completion, is first of all that you can discuss the principles that govern the European Union's legal order. So two key concepts there: principles, legal order. Well, basically once you have achieved this learning outcome, you know about very important principles that exist in the European Union and how they construct this legal order that we have. So why is European law prioritized over national law? Why can you go to a national court to enforce European law? What are the principles, the underlying principles that make that possible? These are just two examples. We'll talk about other principles as well. The second expected learning outcome is that you can say something about, or not say something, but explain the decision-making procedures that exist in Europe, and say something sensible, discuss the different types of secondary legislation that exist, regulations, directives, and so on. The third learning outcome is the judicial protection. So we want you to be able to explain the system of judicial protection. This is about how to enforce the rules. So we know that there are rules in the treaties, for example, or in directives and regulations, but how can, for example, the European Commission actually enforce these rules? For example, against companies that don't observe the European rules, or against member states that don't observe the rules. Or, the other way around, how can an individual actually enforce its rights under the European treaties? How can an individual go to court and enforce its rights? Important courts there are the Court of Justice of the European Union, the COJEU, the General Court, and the national courts. And the latter may be somewhat surprising, the national courts, but you will find out soon enough that actually the national courts, for example, the regional court in the Netherlands or the Hague court, they play important roles in enforcing European rules. The fourth point, the fourth learning outcome, is about the substance. It's about policy areas. So here we move away from the more formal issues of European law, and we're looking into the policy areas, some policy areas. Actually, we look into the key policy areas of the EU, the foundational ones. So not the more recent ones, but the foundational ones. What are they? Free movement of goods, services, persons, and establishment. We leave out the capital. And competition law, which is about fair competition in the European markets. So what we will be doing is present cases on these topics and explain from a legal perspective how these free movements were created in the law and how they can be enforced. The setup is that we have a lecture seminar system. I already said a little bit about that when I introduced the video. So you will be having the 12 lectures, and you will be having approximately 9 seminars almost every week. And the idea is that we prepare your theoretical part in a lecture, and you will apply your knowledge in the seminar. The course book is Karen Davies' Understanding European Union Law. And in addition to that, we have the European Basic Treaties booklet, which contains all the main European Union treaties. Well, a little bit of warning here on the books. The first one, Karen Davies, Understanding European Union Law. It's important that you understand that Karen Davies writes from a tradition of, let's say, common law, the British system, and uses a lot of case law, a lot of cases in our texts. Please note that you do not need to know all these cases. I repeat, you do not need to know all the cases that Karen Davies uses in her book. That would also be quite impressive if you could, because she uses loads of them. But this is not to say that you do not need to know any cases. We do expect you to be able to work with some key cases of the Court of Justice of the European Union and the General Court, and these cases will be announced on the blackboard in a separate list. But in general, you can remember that the cases that we find important will also be highlighted, emphasized much more during our lectures and seminars. The second warning, and then I can move to the next slide, is on the European Basic Treaties book, because this book can be taken to the exam, which is of course fantastic. You can use the book during the exam, only the second book, not Karen Davies' book. You can use the treaties book during the exam. But there's a very important warning here. you cannot write in the book. You cannot write anything, any additional numbers or whatever in the book. Text is not allowed. And please observe this rule. We've had some bad experiences in the past sometimes when this was not done, and invigilators had to take away the exam of certain students and so on. So don't do it, don't write anything on it. What you are allowed to do is underline, underscore, and use highlighting. Different colors you can use to highlight text. You can also use different tabs, colored tabs in the booklet. If you want to know more about this, I can explain that in class. Good. What is the link between the lecture and the seminar? As I said, lecture provides the theoretical background. You should prepare it together with the book. I think maybe first watch the video lecture, then read the literature, and then come to the lecture and then ask questions so you're well prepared to make the seminar questions that you will be doing later on in the week. Please note that we do expect you to be prepared for the seminar, and I will actively involve you also in the seminar. So an answer like, sorry, I don't know, I didn't have time, is not sufficient. The assessment. There will be two parts in the assessment. The first one is an assignment that you will be expected to do at the end of term 1. This will be a written individual assignment, and I will post all the details on Blackboard for that. But basically you will be expected to show some of your knowledge solving a certain case, for example, or giving a legal reflection on a certain policy area. But that will also be explained further in class. The second part of the assessment is by far the most important in the sense of the weighting, because it basically makes up your whole weighting. You get a grade for it. The first part is only pass or fail the assignment. The second part, the open question exam, will be at the end of term 2. If you want to know what the exam looks like, you can have a look already at an old exam that we printed in the module booklet with the model answers. I would recommend that you do not, when you prepare the exam, let's put it like that, that you do the mock exam at the end in the module booklet without looking at the answers. So you try to first see if you can do it yourself and then check the answers only after. Good. That's all the introductory part on the module. Let's talk a little bit about the history of the EU, and we'll do this in huge leaps, so not a lot of detail, but just to emphasize and refresh the knowledge that the EU and the Treaty of Lisbon and the treaties that we have now did not just appear in 2007. There's a history before that. So, the Treaty on European Economic Community 1957, you could say, is the key treaty where it all started. Institutions were created in treaty articles. Remember, all these institutions that we have nowadays in the European Union, of course, in the end, they are traceable back to a legal text, a treaty text. In the treaty text, member states agreed that they would create these institutions. That's how it works. It also created basic articles on legal acts, so acts that actually have effects, and decision-making procedures. Procedures to create actual legislation, to make actual decisions with that are binding and have legal effects as well. Policy areas back then, the internal market, and that we'll be focusing on more in the second part of the module as well. Agriculture, well, I don't think I need to tell you anything about the role that agriculture plays in the European Union and back then already in the community, and competition law. Then we leap forward to 1986, a very important year because the Single European Act was created. And why was it so important, this Single European Act? Because well, first of all, there are other reasons as well, but an important one was that qualified majority voting in the Council was created, so that's QMV on the slide, qualified majority voting, basically meaning that it was possible from now on that smaller countries could be outvoted in the Council. So unanimity was no longer required, no longer all countries had to agree together. If one wouldn't agree, there would be no decision. but with qualified majority voting this was no longer the case, showing this development towards a more supranational institution. New policy areas were created, for example the environment, which is nowadays one of the key policy areas in the European Union, the environment as you may know. And the Court of First Instance was created, which might be a bit confusing because if you have a good memory and you know that we talked about the courts already when we talked about the learning outcomes, and we mentioned the Court of Justice of the European Union and the General Court and the national courts, but not the Court of First Instance. Now, what explains that? Basically, the Court of First Instance is the General Court, so the name only changed. Yeah? So Court of First Instance is the same as General Court. Now, this is the court where individuals, for example, companies can go, and legal persons, legal individual persons such as companies can go if they want to fight, for example, a commission fine. Now, why was this court created? Basically, it was created to deal with the caseload that was so heavy for the Court of Justice of the European Union, so support was needed for that. Then we go again forward to the Treaty of the European Union, the Treaty of Maastricht, and then that's when the European Union was actually created, 1992. Some other key points in that treaty: the European Central Bank and the Committee of the Regions were introduced. Central Bank, of course, plays an important role nowadays. We hear it in the media when there's a crisis again with the euro, for example. And the Committee of the Regions was created to strengthen the role of different European regions and to have their interests also brought into the discussions and weighed into the decision-making of the EU. Some new policy areas were created. Again, we see a growing European Union with growing influence, culture, public health, consumer protection, and trans-European networks. Yeah, I don't think I need to explain these. I think they're quite clear. If not, we can talk about it in the class as well, in the lecture as well. The famous, well, nowadays we no longer talk about it, but back then it was really a big thing. The three-pillared structure, 3 pillars: the community pillar, the foreign and policy and security pillar, and the justice and home affairs pillar. And these pillars all had their different modes of decision-making and their different, let's say, degrees of intergovernmentalism or supranationality. And the EC pillar, the community pillar, was the pillar that was most supranational, where actually the European Union, you could say, was strongest. Co-decision was introduced for the European Parliament as a decision-making instrument. Co-decision is the old name for the ordinary legislative procedure as it's known now. It basically means that the Parliament and the Council co-decide together. Now, for those of you who have done the public specialization, this is a piece of cake. If you've done decision making in the EU, you know that that's the case. You even have simulated it. But not all students have done that. So, hence the explanation. Then we go to Amsterdam. The Treaty of Amsterdam 1997 was not a major a treaty with major impact, but some important things were decided there. For example, the fundamental rights were explicitly recognized as a basis for the EU, or the recognizing these fundamental rights rather. Democracy and rule of law, so sort of underscoring this democratic rule of law state element of the European nations that are part of the treaty. This is an interesting one because nowadays we are facing many issues in Europe. I think of what's happening in Hungary or in Poland at the moment, where especially these issues are under pressure. Rule of law, for example, separation of powers, and so on. The articles were renumbered. Now, maybe not so important, but many lawyers got confused back then. And part of Justice and Home Affairs was incorporated into the European Community pillar, into the transnational pillar, supranational pillar, sorry, such as asylum, explicitly mentioned on this on this slide. So, another change in the Treaty of Amsterdam. Then we go to Lisbon. As I said, we go very fast with big leaps. in Lisbon, and that's where we are now with our current treaty that you have in your European Treaties book, a High Representative for Foreign and Security Policy and President of the European Council was created. So we now have a President in the European Union, and we have sort of a Minister of Foreign Affairs in the European Union. The EU was explicitly recognized as having legal personality, which is important because it means it has its own obligations and rights as an entity itself, as the European Union. A name change occurred. The EC Treaty was now named the Treaty on the Functioning of the European Union, the TFEU, and this is important because in the course we will be using the TFEU almost exclusively, so we will be extensively referring to the TFEU, use the Treaty on the Functioning of the European Union in class and in the seminars and on the exam. Also, the treaty aimed to strengthen the role of the citizens. I don't think it's a secret that the European Union is in a crisis, basically continuous crisis since 2000 and, well, what was it, 5 or so. Yeah, it's not solved yet. And one of the big issues, of course, is that the citizens of the different member states do not feel properly represented, do not feel they are properly engaged in this whole process that is taking place in Brussels. So they try to somewhat remedy that by giving this citizens initiative a chance and increasing the role of the national parliaments as well in the decision-making procedure. Good. That was maybe a bit fast, but we can talk more about this in the classroom if you want. Basically, we did this mainly to show that there was a development in stages in the European, from the European community, economic community, to now the European Union, and that different policy areas were created, different decision-making procedures were adopted, different degrees of supranationalism and intergovernmentalism are there and were there historically, so you are aware of this. A little bit about the legislative framework of the EU. So basically you can see the European Union as a building. It's built up, made up of innumerable laws and legislation. And if you would have to pile up all the directives and regulations from Brussels in front of the school on the central before the entrance, on what's it called, the square before the central entrance, you would get a pile that will pile up higher than the building itself. Most likely, we're talking about thousands and thousands and thousands and thousands of rules. Actually, deregularization is one of the key priorities at the moment for the EU, because there are so many. How does that work? We have primary legislation and secondary legislation. Primary legislation are the treaties. So those are the texts that you have in your booklet, and the European Treaties book. Those are the primary sources. And those are the treaties that were created by the member states. Secondary legislation is the legislation based upon those treaties. Yeah? So if you have a directive, there is always, in one of the first sentences of the directive, you will find that it refers to a primary source of legislation. So it takes into account an article from the Treaty on the Functioning of the European Union, and it gives more effect to that article by giving detailed rules in a directive or in a regulation. That's how it works. Now, this was the first introductory lecture. Here's an example for you. You can't click on it now, but on the PowerPoint version of these slides you can. And there you can have a bit of a feel of a policy area, in this case the environment, and how the European Union has created different rules there, both in directives and regulations, to make that policy field work. So basically that's what it's trying to do by adopting regulations, by adopting directives. It's trying to achieve its policy goals. And here's one example for you to look at. Okay, that was it. The first video lecture. I hope you enjoyed it, found it useful. I'm always open to feedback, so give me feedback should you have any. And I'll see you in class and in the seminar, hopefully. Bye-bye.